for the company to be able to justify that I am dismissed, they've got to have a hearing to find out. Firstly, there's a duty upon them.
Hi guys, welcome to Mamolao. Here we are again, standing on legal business. Don't forget, we are still on Instagram and TikTok at The Real Mamolao. Today, we are going to discuss CCMA processes. Yes, guys, I know a lot of you have been asking me questions on the socials about CCMA processes and how to go about doing certain things. So I've invited an esteemed guest, well knowledgeable in the CCMA processes and all things labor law. His name is Advocate Raynold Brack. Advocate Raynold holds the following positions currently. He is a panelist on the Safety and Security Sectoral Bargaining Council. He's also a panelist in the Government Public Service Sector Bargaining Council. He's part of Tukiso, which is a mediation and arbitration organization. He's in the Education and Labor Relations Council. He's a commissioner for the Conciliation, Mediation and Arbitration, otherwise known as the CCMA. In terms of his education, he has a B.Proc from the University of Western Cape. He also has a qualification as accredited CCMA commissioner, and he also has a Bachelor of Law degree from the University of the Western Cape. And lastly, he has a Master's in Business Leadership completed in 1994. So we're definitely in good company, guys, and you need to listen up. This is vital information for everyone, whether you're an employer or an employee or you know people who are in that sector. Thank you so much and welcome, Advocate, for joining us.
Thank you very much. Thank you for the invite. I'm really excited about this.
You are most welcome. So first things first, Advocate, yes. I just want to understand, or rather for our viewers, what exactly is the role of the CCMA in South Africa?
All right. The role of the CCMA, and I think one must go back historically, is that in the old system, we had the industrial courts.
Okay.
And the industrial courts used to deal with issues that involve disputes and to make it, and not everybody understands these legal terms, but to break it down. If there is a problem between an employee and employee with regard to what happened in the workplace, and it can be that the employee, for example, did something that they were not supposed to have done in the workplace, which upset the employer. And each and every employment situation has got rules under which it operates. So,
right.
So when an employer has the workplace, he has certain things that you can do and that you can't do in the workplace. And if you do something that is not allowed in terms of either the rules of the workplace, or it is a contravention of the criminal law, the employer is entitled to bring action against you. So in the old days, we used to use the industrial court.
Okay.
And of course, in 1996, when we became, after we had become the democracy, in 1996, we established the CCMA.
Right.
The purpose of the CCMA was to augment or take over the role of your industrial courts at that time. And it's aimed at dealing with these fallouts between employee and employee in the workplace, or dissatisfaction by the employee themselves with regard to what is happening with the workplace. Because a lot of people see CCMA as only dealing with issues that have been dismissed.
Right.
But you could be dissatisfied with, for example, you've never been promoted in the workplace. Alternatively, that there are certain benefits that are only given to one group of people that are not given to yourself. Those are also the issues that we deal with at the CCMA. One of them, the ones that's often used, is where employees are dissatisfied with the conditions under which they work. And a lot of times we refer to that as constructive dismissal.
Okay.
And some people misunderstand that.
Yeah.
Because a constructive dismissal gives you the right as the employee to be able to say enough is enough. I'm not going to accept this nonsense by the employer. I am going to find a place where I can complain about this and get somebody to deal with my issue
and be heard.
Yeah.
Okay. So maybe let's start from the real beginning of the processes of
Yes.
going to the CCMA. And there are definitely two main processes.
Yes.
The one is conciliation and the other one is arbitration.
Yes.
So can you just tell us the differences between
All
the
right.
two and the chronological order essentially?
All right. So it's important that we need to start at the beginning. For any matter to end up at the CCMA, there must have been, and I use these terms loosely because I know that a lot of people out there don't understand these legal terms and they just create confusion.
Yeah.
So if I'm dissatisfied with something that happened at the workplace, as I said, and my dissatisfaction could be something that I'd done that was wrong. So, for example, if I'd, let's say, stolen something from the company, and the company has gone through a hearing, because that's the important starting point, is that if I've done something wrong at the company has to put me through a hearing. And normally the wrong that I do in the company has to do with what we call the company's rules.
Right.
Can't come late, can't steal, you can't sit around and do nothing. And so we can go through that.
So company policies.
Company policies and rules.
Right.
Normally it sets out what can be done and what can't be done. So if I've broken one of those rules, then there's a duty upon the company to take me through the process to find out, number one, did I break the rule? And number two, whether or not I had a justifiable reason to break the rule.
Okay.
And so that's where it starts. And that process has got two legs that it stands on. It has what we call a substance in the labor, which means that there must be a good reason for me. There must be a reason for me to have breached the rule.
Right.
Then we have a second part to it, that's procedure. So substance has to do, as I said to you, with regard to the rule that have been breached. But then, for the company to be able to justify that I am dismissed, they've got to have a hearing to find out. Firstly, there's a duty upon them to show that I did break the rule that's in the company.
Right.
And then secondly, what they need to do is that they need to follow a fair procedure by giving me an opportunity to be able to explain what it transpired.
Okay.
So, for example, if they say that you're a constant latecomer, I would say, well, maybe it's true, but where I live, there's two buses. If you miss the second bus, you are definitely going to become late because there's no reason. Or alternatively, I live in an area that's built up. There's regular roadblocks, it's those kind of things. That is why I often come to work late. So that gives a justification as to why are you not there. So if the company then goes through that procedure and they finally dismiss you, that is what starts the process to refer to the CCMA.
Okay.
So we have a breach of the rule.
Right.
The company has gone through the procedure.
Right.
And then the company then under those circumstances say, sorry, we got to part ways because the breach of your rule is so serious. Because that's the important part. You see, it's not just, okay, I come late, so I can dismiss you. The breach of the rule must be so serious enough that I can't continue to work with you in future.
All right.
And we often refers to as the breach of the trust relationship.
Okay.
So in future, I can't trust that you won't come late. You won't come to work late. So under those circumstances, I believe that, look, maybe it's best if we part ways.
Okay.
So then, once you have been dismissed, and it's very, very important that we need to understand on the procedure, is that once you've gone through the procedure where the company has said to you, please tell us why should we not dismiss you, or is there a reason why you did what you did, which we call the procedure. At the end of the procedure, the company would normally say to you, you've got 30 days within which to refer your matter to the CCMA. That's part of the law.
Okay.
And if the company fails to do that, they've actually breached the law. And that is one of the things that you can raise then during your hearing at the CCMA to say that they did not follow the procedure.
Okay.
So now you are warned that you've got to do that within 30 days. And then you've got to then complete the form to the CCMA.
Right.
And the starting point for every process at the CCMA is what we call the 711 form.
Right.
Which is referral of your matter to conciliation.
Okay.
That form is completed. It's got simple details that is required of you on your name, alternative names of people that most probably we can contact with regard to if we want to notify you about something. Then it is very important information that you need to provide to the CCMA. Right. Firstly, when did the event occur?
Okay.
And we call it, when did the dispute arise? When you look at the form, it says, when would the dispute arise? Let me just expand a little bit on that, because I think it's important why that is there. Remember, I said earlier that you would normally be told that you got 30 days within which to refer your matter.
Yes.
The day on which the event happened is important to count those 30 days.
Okay.
So for example, if you are dismissed on the 1st of November, the latest you can refer your matter to the CCMA is the 30th of November.
Correct.
Any day after that means that you are outside the period.
Yeah.
Now, the law has realized that there are going to be delinquents who are not going to keep to the 30 days.
Correct.
So what they have done, they've written into the law a provision that if you are outside the 30 days, you are still entitled to bring your matter to the CCMA, but then you've got to file what we call a process of condonation.
Okay.
In other words, you come to the CCMA, you say, hey, guys, I'm sorry that I am late, but I've got good reason why I am late. It's a matter of I was in hospital, or alternatively, and a lot of things that are raised normally by us as assisting parties in condonation is that I did not have the necessary finances, because that's an important aspect. Remember, you're dismissed from the workplace. You don't have also always the finances readily available. Although, of course, the courts have actually frowned upon that kind of excuse that I didn't have the finances to be able to do so. It's still a matter that needs consideration. You can't just shrug it off,
right,
because sometimes it's a reality.
Correct.
And often we find that people don't work in Gauteng, for example.
Okay.
They work in places like Mpumalanga, or they're in Limpopo.
Yeah.
And so when they refer them to the CCMA or bargaining council, by the way, and we're just focusing on CCMA, but there are also bargaining councils that you can refer your matter to.
Right.
Then under those circumstances, they've got to travel back to be able to deal with this matter.
Correct.
So we're still dealing with what triggers of conciliation. So when you refer your matter in terms of the 711, that's one of the things that the CCMA will look at when you refer your matter.
Okay.
So when they receive your 711, which is the form that you would have completed with all the details, and I was still going through that form. So in your form, you will say, why was I dismissed? And they give you different options in the form.
Okay.
That you can say why you were dismissed.
Okay.
It's either misconduct, which means that you've done something wrong that you're not supposed to. You stole from the company. You were late. You assaulted one of your fellow colleagues. Or we've got a term that's called an unfair labor practice.
Okay.
Now, an unfair labor practice is something that happened in the workplace that you're unhappy with.
Okay.
And they have certain categories under which they cover. So, for example, it's an unfair labor practice when you are not given the necessary benefits that you're supposed to receive, or the company has failed to promote you when they should have promoted you, or they failed to reinstate you in the job when they were supposed to have done that. Alternatively, and this is a very tricky one that is happening nowadays, is that you have been unfairly suspended.
Okay.
Now, just to divert slightly there, because it's important that we need to understand it. A couple of years ago, it would have been a justifiable reason for you to come to us and say to us that you've been unfairly suspended because they did not give you an opportunity to explain why you shouldn't be suspended. Now, 2-3 years ago, the court said, but that's, in fact, the Constitutional Court said, but that's ridiculous. I mean, if the company is going to suspend you, they know the reasons why they want to suspend you. How are you going to convince them that that you should not be suspended? Because, I mean, if they've got reasons why they believe that they're going to suspend you, they're going to suspend you, irrespective of what your reasons are. And your reasons are going to persuade them.
Yeah.
All that the reason does is that we follow the process of what we call the rules of natural justice. They allow you an opportunity to be able to respond as to why you shouldn't be.
Okay.
So we know now that is no longer the case. So that's the other area that you can bring to CCMA, that you've been unfairly treated. The third one is what is a very controversial one, is what we call constructive dismissal.
Yeah.
And constructive dismissal is where you are unhappy with the work conditions and you believe that the company should not be treating you in the way that they are.
Okay.
And as a result of that, you decide that you want to leave the company. And then you resign from the company. And that's the first step of a constructive dismissal.
Yeah.
And then, of course, we've got many others. We've got unilateral changes to your terms and conditions. And all of those are catered for in that form. And so you got to tick the block that applies to you under the circumstances. of the CCMA commissioner who sits will know what am I dealing with regard to that, but also for the CCMA to be able to give a label to what your case is.
Okay.
Because there's a one place where the commission, its focus needs to be drawn as to what am I dealing with as the commissioner at the end of the day.
All right. And then, so now I filled out the form, the 711 form. Obviously, you can fill it out online.
Yes.
ccma.org.za.
Exactly.
Or you can physically go to one of the many CCMA offices.
And they've got cubicles that you can sit there with one of the CMOs to help you complete the form.
Lovely. So I've done that and I've completed the form and my employer is made known that, listen, this person is bringing you to the CCMA. Yeah. Please come on such and such a date.
That's a very, very important aspect.
Yes.
That once the form has been completed, you must first send the form to the employer.
Okay.
So that they are aware that, hey, Ronnie is bringing us to the CCMA because he's unhappy with the way in which we treated him. And this is the reason for that, and it's also preparation for that. And the CCMA, you will then have to prove to the CCMA that you have sent it to the employer.
Okay.
Now, it's very, very important that we emphasize this. If there's a defect with any of those kind of things, the CCMA will not set your matter down for hearing. They will accept your form, but they will not set your matter down for hearing. And that could result in you having to apply for condonation.
Oh,
because you would have been outside the 30 days that you would have expired.
Right.
And the application for condonation is a very tricky one.
Yeah.
And it's really touch and go sometimes with unless of course you got a very, very good reason, like I was in hospital for that period of time, or one of those kind of reasons why I was overseas, or I was in jail, or one of those kind of things. That's why I couldn't refer my matter within that 30-day period. Okay. You would most probably succeed, but it's very tricky, and often people don't complete the form properly, and so commissioners are stuck with one or two lines that normally needs requirement.
So I'm in the room,
yes,
and my employer's there, I'm there, and the CCMA commissioner is there.
No, not yet.
We are there for conciliation.
No, not yet. Because the thing is that once you've sent your matter to the CCMA,
yes,
CCMA will then inform you to come to a hearing.
Okay, you wait for the
so
date.
So they will normally send you a document which we call sent out, and say on the 10th of November you will be in front of Commissioner Raynold Brack. He's going to be the one that deals with your matter.
Okay.
And that is the start of the real process.
Okay. And now I'm in the room
Yeah.
with my employer.
Yeah.
And what basically happens in that room? What do I need to prepare for a conciliation as an employee? And what does the employer then also need to prepare for conciliation? You've previously talked about how there has to be a procedure that happens, and there has to be some substance on the facts of your case. Now, how do we bring those into the CCMA hearing?
Now, conciliation is a very interesting process because it's in the hands of the parties.
Okay.
So the role of the commissioner at a conciliation is the role of a facilitator.
Okay.
So the commissioner helps to bring the parties to the point where they either agree that they would settle the matter amongst themselves peacefully, or alternatively not. Well, my experience of 20 odd years is that they don't often go peacefully.
Really?
But remember, when people are dismissed, the emotions are very high.
Correct.
And sometimes dismissals are preceded by a lot of other things that happened in the workplace. The person who has been dismissed is frustrated. They are disappointed in themselves sometimes, and also in the company. And it can result in us having to be the peacemakers between the parties.
Okay.
So in that room, your preparation for that room is to tell the commissioner, because remember, we are now looking at how can you resolve the issues amongst yourselves. And so there are a couple of important points about that. And the first point is that when we in that conciliation, whatever is discussed in that conciliation is private and confidential to the parties.
Okay.
Like what happens in New York remains in New York.
Correct.
That's exactly what happens when we are dealing with conciliation.
Yeah.
And the role of the commissioner at conciliation is like in any facilitation. The person who has brought the matter will tell me, why did they believe that they were unfairly treated?
Okay.
So I'm saying, but I didn't breach the rule, I breached the rule previously, and the company said nothing, or, John has breached the rule, company did nothing about it. Why am I now in front of the company?
Okay.
And so that's the first thing that needs to happen. Secondly, what do you want out of the process?
Okay.
Because there are different things that some people want out of the process, the possibility of going back to work because they need their job, and nowadays all of us need jobs.
Correct.
I mean, it's a challenging situation. Other people say we don't want to go back to the company because we think it's a terrible company to work for, and so I just want money so that I can get out of that.
Okay.
So the way the process unfolds is that once we've listened now to, because remember, we can't just go on one side of the story.
Yeah.
So once we've listened to what the employee says, they're upset about, and how they believe that we can resolve the issue, it's then when we shift to the employer to say, now, Ronnie says that this is what you've done and this is how you've done it. What is your response to it?
Right.
And the employee can say, Ronnie's a terrible worker. He's been coming late all the time. We've given him many occasions. There are 3 or 4 or 5 written warnings against his name. And so in any case, we don't want Ronnie back.
Okay.
All right. And so we then begin to have a discussion to see how can we bring the parties closer.
Okay.
Say, okay, we don't want Ronnie back. Ronnie wants to be back. Let's begin to talk about this. And then Ronnie says, well, actually, on second thoughts, I don't want to go back. I want money. That is the one thing that can happen. Now, in this process, there are 3 things that can happen. You can either go back to work. When you go back to work, we say that's reinstatement, which means that the company will pay you for the time that you've been away from the work.
Okay.
And take you back, and they'll give a time by which you have to report for duty, etc.
So your employment never broke.
Your employment never broke. It continues, and you will be paid your salary for the period that you've been away.
Lovely.
The second thing that can happen is that you can say that I don't want to go back. But I'm not going to let them get away with this. So I want them to pay me. Now, under normal circumstances, if the commissioner was hearing your case and he had the power to make the decision, you would have been able to give you compensation for a period of 12 months. Now, I think that one must hasten to add here, because it's very, very important, that you can't just come to the CCMA and see it as a lotto.
Yeah.
You can't just come and say that I'm coming here to ask for 12 months.
Yeah.
And to the process, and you say you want 12 months, that's what the commissioner will give, and the company will shrug their shoulders and say, well, we'll take our chances in front of the commissioner.
Yeah.
Because the commissioner might find that 12 months is not what you deserve.
It's not reasonable.
So it's not, and under those circumstances, so it's important that you come there with an open mind.
Okay.
Because a lot of people come to the conciliation and says, I want 12 months, I want 12 months, I want 12. It doesn't matter how many times you're going to say it over and over again. You're not going to get it because it's going to determine on the circumstances. If the company treated you badly and they admit that they treated you badly, they might say to you, we'll offer you 12 months. And that has happened in a couple of occasions where I had been sitting as a commissioner. In fact, it happened in one occasion where a person was offered 14 months.
Sure.
But that's what's going to happen for each and every case. No. So that's the second thing that can happen in the conciliation.
Okay.
The third thing that can happen in the conciliation, the company says, look, we know that you're in dire straits. We know that you're in trouble. We know that the economy is bad. You're not a bad worker. We will re-employ you, but we will watch you.
Okay.
Which means then, of course, you start a new relationship with the company.
Okay.
And you enter into a new contract with them. And the terms and conditions, by the way, can be the same as the other one, but it's a new starting point that you are starting from. Okay. And so under those circumstances, at conciliation, those are the kind of three options that get offered by the parties to one another.
Okay.
In most of the cases, by the respondent to the applicant. That's what we call them, employee. Employee is the applicant and the employer is the respondent.
Right.
And the parties then decide. If you decide that, look, that's what for me, we then move on to the next level that you mentioned, which was arbitration.
That's all we have for this segment. Thank you for tuning in to Mamolao. Please don't forget to subscribe and click on the notification bell for more of this educational legal content. Make sure that you comment, guys. I want to hear from you. And also ask questions because I want to hear those too.